Hi, I'm attorney Eric Trabin. In this video, we're going to talk about arraignments. What is an arraignment, you ask? An arraignment is a type of hearing in a criminal case in which the judge tells you the crimes you're charged with and the maximum punishments you're facing. Florida law requires that all criminal cases have an arraignment. And for many people, the arraignment might be the first time they actually go to court on their criminal case. The arraignment is not the time to tell the judge your side of the story. The reason for this is the judge can't actually do anything during the arraignment, but the prosecutors can certainly use your words against you at a later date. So exercise your right to remain silent. So what should you expect at the arraignment? 3 things. First, you're going to enter a plea. Second, you're going to inform the court of what you want to do about a lawyer. Third, and finally, the court is going to give you court dates. So let's talk about entering a plea. You can enter a plea of not guilty or no contest. A plea of not guilty preserves all of your rights. Now, at this point in time, you and your lawyer haven't had a chance to look at any of the evidence. You don't know what kind of defenses are available, whether any technicalities exist. So in general, it is best to plead not guilty at the arraignment. Now, some people get a little bit scared and are afraid that by entering a plea of not guilty, they won't be able to negotiate a plea bargain with the prosecutor later. But that's not true. In fact, by giving your attorney time to examine the evidence, conduct legal research, and be aware of the legal issues and the arguments that are available, you might be giving your attorney more leverage to negotiate an even better plea bargain. So it's in your best interest to preserve your rights. On the other hand, you could plead guilty. But a plea of guilty means that you are admitting that you are in fact actually guilty. And finally, you could enter a plea of no contest or nolo contendere. If there were to be a plea bargain, a plea of no contest basically means that you're not admitting that you're guilty, but you don't want to fight the charges anymore. You want to accept the deal because you think it's in your best interest. Now, that might be a good way to resolve your case later, but it may not necessarily be the best way to plead at the arraignment. Again, pleading not guilty preserves all of your rights so that you're able to do the research and be prepared to get the best possible outcome. Once you've entered a plea, the judge wants to know what you intend to do about a lawyer. If you intend to hire a lawyer, the judge might set a status date later to find out whether or not you've actually gone ahead and hired a lawyer. If you can't afford a lawyer, you can request the services of the public defender. You'll provide an application to the court, and most of the time they'll tell you right then and there whether or not you qualify and appoint the public defender. And then finally, they'll tell you what future court dates are going to be and tell you that you have to attend them. Now, here's the thing. If you have an attorney before the arraignment, the attorney can waive your appearance so that you don't have to go. Everything that will happen at the arraignment can be accomplished in writing. The attorney can file a written plea of not guilty on your behalf, inform the court and the prosecutor that you are officially the attorney of record, and the court now knows to send court dates to the attorney, and so that you can be excused from that arraignment. On the other hand, if you do not have an attorney by the time of your arraignment, you must attend. Failing to appear at the arraignment and not having an attorney will result in a warrant being issued for your arrest. So not much is going to happen at the arraignment. In summary, you're going to enter a plea, hopefully a plea of not guilty. You're going to be informing the court whether you hire a private attorney or whether or not you need a public defender. And then the court's going to give you additional court dates. So now that you know what to expect at the arraignment, hopefully it's not too scary or intimidating, and you have this information to be prepared at your arraignment.